Hello friends, I hope you are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today, we will discuss the topic of dissolution of marriage under Muslim law, Part 2. In Part 1 of the lecture, Dissolution of Muslim Marriage, we discussed the dissolution of Muslim marriage by the husband and wife and divorce by mutual consent of both husband and wife. In today's lecture, we will discuss the dissolution of marriage by judicial decree of the court. So let's start with an introduction. The Dissolution of Muslim Marriage Act 1939, it provides various grounds for enabling a wife to seek divorce from her husband. According to Section 2 of the said Act, women married under Muslim law have the right to obtain decree for the dissolution of marriage on the 9 grounds specified in the Act. A Muslim lady has no right to dissolve her marriage herself. It is necessary for her to apply to the court for the dissolution of a marriage on the grounds mentioned in the Act. Only the court's decree can dissolve the marriage. In the case of Abdul Jalil Ahmad versus Marina Begum, 1999, an application was filed by the wife for divorce under the Dissolution of Muslim Marriage Act 1939 on the ground that the husband has failed to perform his marital obligations and has treated her with cruelty. Thereafter, a joint application was filed both by the husband and the wife to pass a decree in the terms of application filed by the wife. The family court held that a decree of divorce on a mutual consent is not known under the Dissolution of Muslim Marriage Act of 1939. Prior to the passing of Dissolution of Muslim Marriage Act 1939, the wife could apply to the court to dissolve the marriage on 3 grounds. Firstly, impotency of the husband. Secondly, false charges of adultery. Or thirdly, repudiation of marriage by wife. The Dissolution of Muslim Marriage Act 1939 made revolutionary changes in the prior law and provided 6 additional grounds on which a wife may apply to the court for dissolution of marriage. Thus, under the Act, 9 grounds have been provided under which a Muslim wife may obtain a decree for the dissolution of marriage. So now we will be discussing these grounds on which marriage can be dissolved by judicial decree one by one. First, we will discuss the absence of a husband. Section 2, Clause 1 of the Dissolution of Muslim Marriage Act 1939 says that a woman married under Muslim law shall be entitled to obtain a decree for the dissolution of marriage if the whereabouts of the husband have not been known for a period of 4 years. The decree passed on this ground will not take effect for a period of 6 months from the date of such decree. And if a husband appears either in person or through an authorized agent within that period and satisfies the court that he is prepared to perform his conjugal duties, the court must set aside the decree. The wife must detail in the complaint the circumstances that led to the party ceasing to cohabit, the location and the time of defendant's last sighting, and the actions taken to locate the defendant. Further, now let's discuss the second ground for dissolution of marriage, which is failure to maintain the wife. If the husband has neglected or failed to provide for her maintenance for a period of 2 years, a married Muslim woman can obtain a decree for divorce. However, the husband under Muslim law is not bound to maintain his wife, who is not faithful or obedient to her husband or who does not perform her marital duties. The case of Fazal Muhammad versus Umatur Rahim, 1949, established that a wife cannot claim maintenance if she refuses to live with her husband or fails to fulfill her marital obligations without a valid reason. Under such circumstances, she has no right to claim divorce under this act. In another case, Yusuf versus Sorama, 1971, a girl of 17 years was married to the appellant defendant, who was twice her age. After having lived for a month in her husband's house, she went back to her parents and lived separately for over 2 years. During this period, the appellant admitted his failure to maintain his wife, but alleged that he was willing and anxious to keep her with him. Justice Krishna Iyer rejected the husband's plea and upheld the decree for dissolution of marriage. The court held that a Muslim woman under Section 2, Clause 2 of the Act can file a suit for dissolution of the marriage that she has not, as a fact, maintained, even if there is a cause for it. In the opinion of the court, the reason why the husband has not maintained the wife for a statutory period of 2 years is immaterial. The wife is entitled to a decree for the dissolution of marriage on this ground if the husband does not maintain her for 2 years. Although during this period she lives separately from him without any reasonable excuse. Further, the husband cannot defend the suit merely on the ground that he was unable to maintain her due to his poverty, failing health, unemployment, imprisonment, or any other ground, unless it is submitted that her conduct has been such as to disentitle her to maintenance under Muslim law. Under Section 125 of the Criminal Procedure Code of 1973, a wife can claim maintenance and not divorce. Section 2, Clause 2 of the Dissolution of Muslim Marriage Act 1939 allows a Muslim wife to file for divorce if her husband has neglected or failed to maintain her. Under Section 4 of the Muslim Women Protection of Rights on Divorce Act 1986, the court may pass an order in respect of a divorced woman for maintenance. Further, let's discuss the third ground for dissolution of marriage, which is the imprisonment of the husband. Under Section 2, Clause 3 of the Dissolution of Muslim Marriage Act 1939, a woman married under Muslim law shall be entitled to obtain a decree for the dissolution of a marriage if her husband has been sentenced to imprisonment for a period of 7 years or more. Now further, let's discuss the fourth ground for dissolution of marriage, which is failure to perform marital obligations. If the husband has failed to perform without reasonable cause his marital obligations for a period of 3 years, the wife can get her marriage dissolved by means of a divorce. It shall not be out of place to mention that if the husband swears that he will not have sexual intercourse with his wife for any time above 4 months and subsequently abstains from such connection with her within 4 months, an irrevocable divorce takes place, independently of any decree of dissolution from the court. Further, let's discuss the next ground for dissolution of marriage, which is the impotency of the husband, under Section 2, Clause 5. If the husband was impotent at the time of marriage and continues to be so, the wife may file a suit to dissolve her marriage. Impotency means the inability to consummate a marriage. In order to succeed, the wife will have to prove that, firstly, the husband was impotent at the time of marriage. Secondly, the husband was impotent at the filing of the complaint. And thirdly, he continued to be impotent from the date of marriage to the date of filing the complaint. The proviso of the section says that before passing a decree on this ground, the court shall, on application by the husband, make an order requiring the husband to satisfy the court within a period of 1 year from the date of such order that he has ceased to be impotent. And if the husband so satisfies the court within such a period, no decree shall be passed on the said ground. The burden of proof will lie on the husband to prove that he is not impotent. Now let's discuss the extent of right to privacy in matrimonial matters pertaining to impotency. In the case of Zahida Begum versus Mushtaq Ahmed in 2006, the defendant was impotent. He was unable to perform matrimonial obligations. The marriage could not be consummated as the defendant was impotent. The trial court directed the petitioner to undergo a virginity test at the hands of a gynecologist. The question was whether the right to privacy was invaded in the matrimonial case, where the parties were subjected to a medical test. This point was set aside by the apex court in Sharda versus Dharampal, decided in 2003. The apex court, interpreting Article 21, ruled that the privacy of a person is not an absolute rule. In a matrimonial case, directing the parties to undergo a medical test does not offend Article 21. The apex court also cautioned that such power will have to be exercised only if the applicant has a strong prima facie case. Now moving further, let's discuss the next ground for dissolution of marriage, which is insanity, leprosy or venereal disease under Section 2, Clause 6. If the husband has been insane for a period of 2 years or is suffering from leprosy or virulent venereal disease, the wife may file a suit for the dissolution of her marriage. It is important here that the leprosy and virulent diseases need not be 2 years old. They may be even recent. It is not necessary that the husband has been adjudged insane or that he has been committed to, confined to, or placed under the supervision of a mental disease institution. But if there is such a declaration or confinement, that is sufficient proof of insanity. So now let's discuss the meaning of the term insanity. It's not easy to define insanity. It exists when the brain and nervous system are in their normal condition and mental functions can be performed in their usual manner. Insanity is an abnormal state when one or more of the above mentioned mental functions are not performed in the normal way or are not performed at all due to some defect or disease of the mind. Section 2, Clause 6 of the Dissolution of Muslim Marriage Act 1939 enlists the husband's insanity and for a period of 2 years, leprosy or virulent venereal disease. Under the Act, the law applies equally to all Muslims, and the insanity of the husband would entitle the wife to obtain dissolution of marriage. The Act does not define insanity. It is submitted that the term insanity should not be interpreted strictly. General unsoundness or derangement of the mind or mental disorder resulting in the inability to manage one's own affairs and lack of proper sense of social behavior to manage one's own duties are generally sufficient for the purposes of this Act. So friends, further let's discuss the meaning of leprosy. Leprosy is an agonizing, sane or ulcerous type of disease in which human being becomes deformed and is unfit for sexual intercourse. Under Section 2, Clause 6 of the Dissolution of Muslim Marriage Act 1939, a Muslim lady can seek divorce on the ground that her husband is suffering from leprosy. The Act does not use the word virulent for leprosy. Only a simple type of leprosy will be sufficient for seeking divorce. Further, let's discuss the meaning of venereal disease. Syphilis, gonorrhea, and soft chenier have been defined as venereal diseases under the English Venereal Diseases Act of 1917. Section 2, Clause 6 of the Dissolution of Muslim Marriage Act 1939 says that a Muslim lady can ask for dissolution of marriage if the husband has been suffering from leprosy or any form of venereal disease for 2 years. Moving further, let's discuss the next ground of dissolution of marriage, which is the repudiation of marriage by the wife. A woman married under Muslim law shall be entitled to obtain a decree of divorce on the ground that she was given in marriage by her father or other guardian before she attained the age of 15 years and repudiated the marriage before attaining the age of 18 years, provided that the marriage has not been consummated. This provision clearly states that all restrictions on the option of puberty in the case of minor Muslim girl whose marriage has been arranged by her father or other guardian have been abolished, provided three conditions are satisfied, namely, the first, marriage took place before the age of 15. Second, she repudiated the marriage before attaining the age of 18. And thirdly, the marriage has not been consummated. The mere exercise of the option of repudiation does not operate as a dissolution of the marriage. The repudiation must be confirmed by the court. Until then, the marriage subsists, and if either party to the marriage dies, the other will inherit him or her as the case may be. In the case of Mustafa versus Khurshida, decided in 2006, marriage was dissolved under Section 2, Clause 7 of the Dissolution of Muslim Marriage Act 1939. The petition was filed by the wife. The petitioner claimed that she was only 7 years of age at the time of marriage and that marriage was never consummated. The birth certificate and passport of her mother proved that the petitioner was 7 years and 23 days of age at the time of her marriage, as contracted by her parents. It was also corroborated by the ration card. It was proven that the petitioner and the respondent had never lived together as husband and wife. There was no cohabitation at any time. It was held that she lawfully exercised the option of puberty and repudiated the marriage upon attaining the age of 18 years. She was therefore entitled to the grant of divorce. Moving further, let's discuss the next ground of dissolution of marriage, that is cruelty, under Section 2, Clause 8. Even before the passing of Dissolution of Muslim Marriage Act 1939, cruelty was recognized as a good ground for the wife to seek divorce. In the case of M. Begum versus M.K.R. Khan, decided in 1933, it was said that cruelty was sufficient ground for dissolving the marriage. Under the Dissolution of Muslim Marriage Act 1939, judicial divorce may be claimed by a Muslim wife if the husband treats her with cruelty under the following circumstances. First, habitually assaults her or makes her life miserable by cruelty or bad conduct, even if such conduct does not amount to physical ill treatment. Second, associates with women of ill repute, leads an infamous life. Third, attempts to force her to lead an immoral life. Fourth, disposes of her property or prevents her from exercising her legal right over it. Fifth, obstructs her in the observance of her religious profession or practice. Sixth, if he has more wives than one, he does not treat her equitably in accordance with the injunctions of the Quran. The concept of cruelty has been undergoing a change along with the change in social and economic conditions of our society. In the case of Shakila Banu versus Ghulam Mustafa, decided in 1971, the court held that an unwilling wife cannot be compelled to live along with her husband. Cruelty can take various forms. It depends on various factors like health, environment, education, economics, and social background. Formerly, unfounded imputations of wife's chastity were held to not amount to cruelty. Today, the courts maintain that persistent charges of adultery and immorality amount as to much cruelty as was decided in the case of Iqbal Kaur versus Preetam Singh in 1963. Today, psychological injury or harm, gross neglect, the intention of a spouse to cause injury or harm to the other spouse, and the inability of the husband to satisfy conjugal greed are grounds of cruelty. In the case of Nafisa versus Shamim Ahmed, decided in 2011, the husband used to physically assault his wife. She had to leave the house in a pregnant state. It was also contended that the husband neglected to maintain her and her children. It was proven that the husband treated his wife with gravity. Therefore, marriage between the parties was dissolved, and a petition for divorce was granted under the Dissolution of Muslim Marriage Act of 1939. Further, let's discuss the next ground of dissolution of marriage, that is, on any other ground that is recognized as valid for the dissolution of marriages under Muslim law under Section 2, Clause 9. This clause covers the divorces of Ila, Zihar, Khula, Mubarat and Tafweez. This is a residuary ground on which a Muslim wife may seek the dissolution of marriage. The Act proceeds to lay down a residuary provision in order that the wife may not lose the benefit of any other ground that may have escaped the attention of the Parliament. The imputation of unchastity or false charges of adultery against the wife, which is lien, makes good ground for the dissolution of a marriage. In the case of Noor Jahan Bibi versus Qasim Ali, decided in 1977, Noor Jahan filed a suit against her husband Qasim Ali, who charged her that she was of bad character, that she was enamored by one Asghar Ali, and that she committed adultery with him. It was held by the court that the doctrine of lien has not become obsolete under Muslim law. Therefore, a Muslim wife can bring a suit for divorce against her husband on the ground that her husband has been charged with adultery falsely, by virtue of Section 2, Clause 9 of the Dissolution of Muslim Marriage Act 1939. Thus, we can conclude today's lecture by saying that divorce must be for a reasonable cause. Under the Mohammedan law, marriage, though regarded as a civil contract between a man and a woman, becomes husband and wife after the solemnization of the marriage, and their respective rights and obligations are regulated by the rules under the relevant law. This being the position, marriage is the basis for social organization and the foundation of legal rights and obligations. The modern concept of divorce also holds that matrimonial status should be maintained as far as possible. Under Section 7 of the Family Courts Act 1984, cases relating to the matrimonial status of any person are referred to the jurisdiction of the family court. The family court aims at reconciliation and persuasion of parties to arrive at a settlement. For these reasons, if a Muslim husband divorces his wife at his whims and caprice, it would not only be a spiritual offense, but it would also affect the divorce. In the above view of the matter, a Muslim husband cannot divorce his wife at his whim or caprice. That is, divorce must be for a reasonable cause, and it must be preceded by pre-divorce negotiations before arriving at a final decision. So with this, we come to the end of today's lecture. Thank you so much.